Welcome, listeners. Welcome the audience of this YouTube channel, Lex Consilium Foundation, for the playlist in Similie. Our guest today is Senior Advocate Mr. Sudhesh Pai, a very well known author and jurist, and he finds time to write books, to attend seminars, address there, despite the very busy, tight schedule he has as in his busy practice. So, welcome, Sudhish. I would like to ask you today a specific question that very often the huge pendency before the different courts in India is talked about, discussed. It's a matter of concern. But it is also felt that the only remedy to this suggested and taken up is with regard to the increasing the number of judges. And I'm referring to that at the start of the constitution when it came into being. Look at the number of the judges in the Supreme Court, and even in High Court the numbers have gone up. But a question that comes to my mind is merely the increasing the number of judges going to deal and going to reduce the pendency? I believe someone had recently worked out and indicated that even if there is no new admission, then it will take years and decades for the present
backlog to be cleared.
pendency, the backlog to be demolished if it can be. Now, having regard to this, the point that I would seek your views is that increasing the number of judges is one, but then there has to be a wholesome view on this approach along various directions, various fronts. And one of the suggestions that was made was that we should limit the time for the arguments of the consuls, which in some cases are extraordinarily long. And secondly, also limit the length of the judgments in very many cases, because these also tend to be quite lengthy and verbose. What would you say in that regard?
Yes, to respond to your first statement, increasing the number of judges perhaps is not the solution. Increasing the number of judges many times may be counterproductive. The issue is what kind of judges do we appoint? I'm sorry, I again mean no offense to anyone, past, present, or future, who may be on the bench. But I think if you have good judges, competent judges, things would be, I'm not saying you would, everything would be, you would be in heaven. No, not that. But things would definitely be far, far better. I understand this is the position across the spectrum in most of the high courts. In the good old days, not good old, a few years ago, forget the good old days, admission work in the high courts used to be over, say by about 12, and regular hearing work would be taken up, and that's the real work. Today, even at 4:30 or 5, admission work does not get over. Many times we have also seen judges at the admission stage trying to, dispose. I may be wrong, but my own view is I'm not able to appreciate this, because by doing that, you dispose of today's case and keep a 2015 case pending. And we talk of pendency. There may be cases which you can dispose it off in 10 minutes, 15 minutes, by all means. But if you have to take 2-3 hours to dispose of today's case, that much of time is lost for the case of yesterday and the day before. This happens many courts. If it is admissions, this again as a matter of theory and concept. After all, what is admitting a case? It only means it requires consideration. Something is to be heard, considered, and then decide. If that is so, is not a time of 5 minutes enough for you to decide whether the case requires consideration? If you have to hear it for 1 hour, then definitely it requires consideration. Why do you waste that time? Again, there may be exceptions and cases. You can't have a universal thumb rule. But broadly, this is what I have been saying, and I don't know. I hope I am not wrong. See, if a case requires consideration, admit it. You don't have to hear for 1 hour. I think 5 minutes is the maximum if a point is made, so that you proceed and take up hearing cases. I'm not saying that this is the final and wholesale solution to all our problems, but this, like every drop of water adds to the ocean. All these steps do add to the whole thing. And then long-winded judgments and long-winded arguments. Yes, again they say a good judge controls the counsel without being offensive. There are cases you can't have a thumb rule and say let us not compare the American Supreme Court. That's a totally different cup of tea. They take up 126 cases a year. I think each judge has 120 cases and more a day in India. So we can't have that comparison. And then they file their written briefs, which are perfect. Judges read them from end to end, discuss them, and then that half an hour thing, the whole thing is different. And even for that, two views are expressed even by American lawyers. There's a beautiful article way back 50 years ago, sometime in the 70s, by an eminent counsel who came from America to England, across the Atlantic, and wrote an article. The title is "Gentlemen, Their Lordships." That's how, when the House of Lords assembles, it's announced, "Gentlemen, their lordships, the law lords are coming and you rise."
Yes.
There you have oral arguments. And the American lawyer compares the two and opts for the English oral arguments as a better system. So we can't say that's a different question. Long arguments are not necessary in every case. There's no doubt about that. The lawyer has to be fully prepared. The judge's uptake is important. Let's not shy away from this. After all, a lawyer has to convey. That is a joke, not a joke. I understand it did happen in some high court in the 50s or 60s. The judge asked the lawyer, "How long would you take?" "As long as it would be necessary for your lordship to understand what I am saying."
Quite right.
So, so when the uptake is better, the things move faster. There are cases, you can't have a big constitutional case, you say, argue in 1 hour or 1 day. No. If you do that, you will not be doing justice to the issue. Long-winded judgments, absolutely, I do agree. Every case does not require such lengthy judgments. What we notice now, the arguments of counsel of both sides are set down verbatim, almost verbatim. Is that necessary? You must note that. It's not that you overlook the arguments and proceed to your judgment. You note the arguments, but you could do it in a much more condensed form. On your channel, we were talking of Justice Murray Cutes Trotter of the Madras High Court, the greatest English Chief Justice who sat in Madras.
Yes.
And one of the points that I spoke is that you cite to him any number of cases, he could, within few sentences, without missing any point, capture the essence of those judgments. So you can, capture the essence of the arguments, and then you don't have to
adopt that line. Yes.
Yeah. And in fact, I have commented on Supreme Court judgments that they have stopped being judgments, more in the form of theses. And judicial statesmanship has given way to legal journalism. I have said this in writing, meaning no disrespect, but when we talk, I think we must the issue. There are cases where you require long judgments. Yeah, there's no doubt, but not every case is of that. So it would depend on. We come back to again. But this is how to get them. I have no answer, and I'm sure no one would have an answer.
As long as the need has been felt.
Yeah, good lawyers,
some
lawyers and good judges.
Thank you.